Good morning to all. My name is Rosa Celorio, and for those that do not know me, I serve as the Burnett Family Associate Dean and Distinguished Professorial Lecturer in International and Comparative Legal Studies at GW Law School. It's wonderful to be here in this lecture. I wanted to tell you that this lecture in particular is going to focus on exam taking, and I'm actually going to discuss a number of issues that are very important on exam taking, including tips to succeed, best practices during exams. And I'm also going to discuss a specific hypothetical exam that you should have received at this point and a model answer for that hypothetical exam. You probably recall that you already had practice exams and fundamental issues in US law. So this lecture is meant to be a complement and to give you more of a flavor of what exams look like at GW Law School. As you probably know already, our exams are really focused on issue spotting. Basically, you're asked to identify specific legal issues and apply them to a specific fact pattern. They look very different to exams at the undergraduate level and other schools. This is why it's very important to have a little bit of practice before you take exams at the law school level. And one thing that's very important for you to know about exams at the law school is that we really try to emulate what attorneys do, in the US legal context. For example, if you are an attorney, practicing in the US, usually you receive clients, you advise clients, usually those clients will give you and relay a number of facts, and you will have to basically spot and advise those clients on specific legal issues. The clients are not going to tell you the specific legal issues, you have to identify them yourself. And this is also what a lot of our judges and attorneys, especially those that are prosecutors and defense attorneys and others that serve in the court system, this is what they do on a daily basis. So a lot of our system is really devoted to that, to training students to identify those legal issues and then to be able to apply them to specific facts. This is why we have a lot of exams that are like that. And you'll see in the model fact pattern that was shared with you that it gives you an example of questions that we ask in the exams. One thing that I want to tell you before we actually move on, to those exam taking tips and potential best practices and also reviewing that model answer is that outlining is critical to succeed in your exams. We always tell students, that it's very important to work on your outlines throughout your semester, to not leave this to the last minute. Outlining is a process in itself. It teaches you, how to absorb those legal rules, that legal reasoning from the cases that you are discussing in your classes. It also allows you to organize those rules. And it's very important to have those rules organized because that's what you're going to be applying to specific fact patterns, during your final exams. So it's very important that you work carefully on those outlines, that you don't leave them to the last minute, so that you actually go through the process, of learning how to absorb those rules from specific cases. And as taught by your professors already, especially in the legal research and writing course, when you are working with outlining, it's good to follow the syllabus of your classes as well. It's a way for you to organize material. So I really encourage you to devote a significant amount of time to these outlines because this will really help you with your exam taking later. A few things about exams as well in the law school. Exams in the law school can be in person or they can be take-home exams, which means that you upload them from the course portal and then you prepare the exam over a period of time and then you basically upload or submit that response through the course portal as well. The records office will provide training on this. There's a lot of videos on how to do this. So you will be provided training on all of this. Usually your professor will include in the syllabus instructions of what kind of exam you're going to have in that specific class, whether it's going to be an in-person exam, whether it's going to be a take-home exam. And also one thing about our exams, some are closed book, which means that you can only have your outline there, but not other materials to refer to. But then you also have many exams that are open book, which means that you have all of your materials with you, including your outline as well. But this is all instructions that your professors give in class, and also usually this is in the syllabus. It's okay to ask your professors for questions on what the format of the exam is going to be. I'll give you one example. Usually are fundamental issues in US law classes, which most of you are required to take. Usually we do open book exams and we do take-home exams, right? And this is something that's in the syllabus, or the professors tell you throughout the semester. They give you instructions on this. It's very important to listen very carefully to the instructions your professors give you on exams. But without further ado, I have a PowerPoint and I want to start talking about those exam taking tips, which I think are very important when you are navigating this particular component of your law school education. A few things about exams. It's very important to keep in mind that what you're being tested on is how to apply the material learned, which means I always tell students, focus on the basic legal rules, the basic legal cases, the basic constitutional provisions, the basic statutes. Remember all of those sources of US law, focus on those. And be ready to apply them to specific facts or new facts. This is why it's very good to practice, when you are, discussing a specific case in a class. That's an example of how a specific rule can be applied. But remember that this is a common law system. This is a stare decisis system, so that means that, there's going to be many other different kinds of facts, and there's many different ways in which that rule can be applied or not applied in the future. So it's always good to have that in mind when you're studying the material. And this is where the outlines really help you. I always tell students, it's very important to get enough sleep. The reality is that since you're going to be applying facts and you're going to be doing all this legal analysis in your exams, it's never good to not sleep. It's never good not to take care of yourself. It's never good to be too stressed out. The reality is that this is an exam. It's within the law school. The reality is that there's a lot of things around the world that are more serious than exams, and we always say that it's good to take your exams seriously, but it's also very important to take care of yourself. So please keep in mind your wellness. It's also very important to get enough sleep before your exams as well. A few other things about exams: grading is anonymous. This means please do not put your name or anything that identifies you in the exam. For example, your country of origin, anything that could give your professor an idea of who you are. You do not want to include that in the exam, especially your name, because blind grading is basically a very important pillar and rule at the law school. The other thing that I encourage you to do is review exam instructions very carefully, and I cannot even overstate that. The reality is that a lot of students don't do this, and then they're very confused during the exam. It's very important that as soon as you have access to those exam instructions, you do review them carefully. And for take-home exams, make sure that you review your instructions as soon as they are posted. Do not wait. It's always good to kind of understand what your professor is asking you to do and the timeframes that you have to do it. The other thing that's important for you to do is when you think of that outlining, remember that we're talking about outlining in general, it's very important to use your same outline for the exam. I always tell students, when you participate in the Olympics, for example, when you see those athletes, they use the same tennis shoes and they use the same shoes that they have been using in practice. It's the same thing with exams at the law school. You want to use the same outline. You don't want to use a new outline that you're not familiar with, and you want to test drive that outline. It's good to think about alternative fact patterns, and other ways in which to apply the rules that you have been discussing in class. Another important rule of thumb is that when you are working on your exams, especially your take-home exams, make sure to know that our records office, our Dean of Students office, and our IT department are only available during business hours. This means 9 to 5, Monday through Friday. This is extremely important. It's important that you organize yourself. I don't think it's a good idea to be downloading an exam on a Saturday or a Sunday, because you're not necessarily going to have the support if you have any sort of problems, downloading that exam, especially when it comes to take-home exams. So it's good to train yourself that it's only 9 to 5 between Monday and Friday. Other important rule of thumb is do not contact your professors during the exam. A lot of students do this, and this is against school rules. It's very important for you to know that you're not supposed to talk to your professors at any point during the exam period. If you have any sort of questions on the exam, feel free to reach out directly to the records office, but you're not supposed to be contacting your professor, even if you have doubts, okay? Other things about the exam content and format. I always tell students, there's always a tendency to want to be very advanced and very nuanced and very detailed, when it comes to exams. And there's nothing wrong with that, but a lot of what your professors are testing you on is on that basic legal doctrine and standards and rules. So make sure that you do have the basics down before you go into any sort of details. If you do have time, then you focus on those nuances and then you focus on those details. But make sure that those basic legal rules and those cases are there. And also remember that you are being tested on what was discussed in class. Most professors will not count or will not give you extra credit for material that you cite in an exam that wasn't discussed in class. So feel free to keep that in mind, when you're preparing for exams as well. In terms of the exam content and format, it's always good to organize your exam. I always tell students that it's good to have headers, to have bolded text, to have underlined text, especially the cases. It's good to underline your case names or by party or by legal issue, depending on the specific instructions on your exam or the question that you're asked. But it's good to organize your exam. And I always tell students, that it's good to start with a list of legal issues to make sure that you get credit for those, especially in in-person exams that you may not have time to be able to complete an answer for each legal issue. At least if you start by listing them, you get credit at least for having recognized them, right? And then you can discuss them, in your own time. Other things that are important, I do think it's very prudent to underline case titles, but there's no need to include the full case title, and there's no need to do blue booking in an exam as well. And remember, this is a very, very important rule of thumb, when you're working on your exams. Usually, if you have a question and you have a fact pattern and your professor is asking you to spot issues, it's very important to identify those rules, to present those rules, to present the cases in which those rules were discussed, and to apply them to the facts. Make sure you do both. A lot of students, they only discuss rules, but they don't apply them to the facts. And remember that what we're asking you to do is that issue spotting on a fact pattern, and then you apply it to the facts. And I'll give you a few examples when we go over the model answer on the mechanics of how that works. And another thing, lastly, that I really want you to keep in mind is that plagiarism policies apply to exams as well. So I always tell students, no cutting or pasting, no using language that's not yours. The reality is that we want to see your own analysis, right? And you have to trust yourself. I always tell students, that when students commit plagiarism, it means that they don't trust their own thinking. They don't trust their own analysis. And that's not a good practice. We are training, the future lawyers, talented lawyers. You're all very talented to be here. So I don't think it's ever a good thing or beneficial to resort to plagiarism. Okay, so let's go on and discuss that practice or that practice exam that I gave you, and that sample answer. And I wanted to give you that practice exam. It's a past exam, that I gave a number of years ago, in my fundamental issues in U.S. law class, and it can really be similar, to the kind of fact patterns that you're going to see in many exams at the law school. And I'm using as a model, many responses that I've seen, over the years that I think are effective, that can really earn a better grade for you. So a lot of the tips are also based on experience, and a lot of the models are also based on the experience as well. So as I indicated, it is a really good idea when you're working on your exam answer to list the issues, the legal issues that you see in that fact pattern. And the reason is that you may run out of time, especially if you're working on an in-person exam, you may have 2 hours, 3 hours, maybe 4 to prepare that exam, and you may not have enough time to actually discuss the issue. So it's good to list them initially, and then you discuss them to make sure, that your professor knows that you were able to identify them, right? And so that you get, and to make sure that you get credit for having identified them. So in the specific fact pattern that was shared with you, I identified 5 issues in particular, but please note that these are not the only legal issues in that fact pattern. You may identify more, you may identify less. This is part of the issue spotting exercise. And this is a legal system that really values, that specific look, or different look to different fact patterns, and basically that extraction of legal issues from a fact pattern, right? So I'll give you these 5 examples. When you look at that pattern, one of them is whether Laura can bring an action in federal courts against CentroPro and Aventura under the Alien Tort Statute, which is commonly discussed in fundamental issues in US law, for human rights violations allegedly committed against individuals in the local community in Luciérnaga. I frame it as a question, for example, but you don't necessarily have to frame this as a question. It can also be a straightforward legal issue. The next question, can the Alien Tort Statute apply in this case, notwithstanding the presumption against extraterritoriality advanced by the United States Supreme Court in the Kiobel case? And see how I underline the Kiobel case, but I don't cite the whole case and I don't blow up the case. A second issue, whether or not the president can bring an action against Laura before federal courts for the disclosure of classified government documents. A third issue, whether the seizure of arms from several well-known United States companies by the US president is constitutional. A fourth issue, whether the 10-day detention of Laura by the FBI without a warrant violates her constitutional rights, and in particular, the due process clause of the 14th Amendment in the US Constitution. And lastly, can Laura present a habeas corpus claim at the state court level or submit a claim before US federal courts under 42 USC 1983, challenging her 10-day detention, right? So let's go on to the analysis of the issues, because remember, you list the issues, but then you analyze each of the issues, and you want to make sure that you give enough time yourself, enough time to be able to do this. A few things when you look at this analysis of the legal issues, it's very important that you present the rule and then you apply it to the facts. Make sure that you cover both aspects in your answer. This is extremely important because a lot of students either discuss only the facts or discuss only the rules. And usually your professors are looking for you to do both. So in this particular case, remember that there was this Alien Tort Statute issue that we already read, that I already read, in the previous slide. So in this particular case, this would be the presentation of the rule. The US Supreme Court in Kiobel held that there is a presumption against extraterritoriality and that harms which occurred outside the United States need to touch and concern the territory of the United States to activate the application of the Alien Tort Statute before federal courts. In this case, the alleged human rights violations occurred outside the United States. Remember, you start applying those facts as you navigate the rule. The corporate activity, which presumably caused these human rights violations, occurred outside the United States. The corporations which are involved, CentroPro and Aventura, do have satellite offices in the United States, but there are no facts connecting the activities of their US-based branches with the Luciérnaga project. The US Supreme Court makes clear in Kiobel that mere corporate presence is not sufficient to rebut the presumption against extraterritoriality. Even though the people of Luciérnaga have family members living in the United States, the singular fact is probably not sufficient to overcome the presumption against extraterritoriality. Therefore, an action before federal courts based on the Alien Tort Statute will most likely not prosper. And remember, when you look at that fact pattern that I gave you as an example, remember that narration of facts, but also remember that question, that question that the fact pattern is asking you. Please describe the advice that you would give Laura as to the legal issues relating to her situations with Televideo, the local community in Luciérnaga, CentroPro and Aventura, the US president and the FBI. She wants to know which legal actions she could pursue and claims that she may face in the future. So this is part of that response, okay? So let's go to a second issue, and this issue is really related to the president, and the executive branch, which is a major focus of discussion in most of our fundamental issues in US law classes. And remember that the issue was whether or not the president can bring an action against Laura before federal courts for the disclosure of classified government documents. One thing that you will notice in this model answer or this model description of this particular legal issue is the allusion to a number of cases. You don't necessarily have to focus your answer on just one case. You can actually include a number of cases in your answer and then apply them to the facts. And remember that another thing that's key is that don't worry so much about the result. A lot of what your professors are testing you is the process of applying the rule to the facts. The reality is that there's a lot of litigation in the United States. The reality is that not every attorney applies the rule to the facts, in the same way. So don't worry so much about the result. It's more the process, that your professor sees that you really have, that you really studied these rules and that you were able to apply them to the facts. So for example, in this particular case, it says, the US Supreme Court in Nixon versus United States recognized the need for the US president to have privileged and confidential communications, and this is particularly important in matters concerning the military and national security. However, the US Supreme Court also clarified in the Nixon case that presidential privilege is not absolute. This means that a mere claim of privilege related to classified documents without any assertion of a need to protect military, diplomatic, or sensitive national security secrets can be insufficient in criminal justice proceedings before federal courts. A claim for a general privilege of confidentiality needs to be weighted with the goal of a fair administration of criminal justice and the power of judicial review. The broad scope of the power of judicial review of US courts under Marbury versus Madison is also relevant to the legal analysis of the facts presented. In the facts presented, it seems that the classified documents released by Laura were related to an order issued by the US president authorizing the seizure of arms from several well-known companies to deliver to the government of Luciérnaga. And this order was issued on national security grounds. Since the classified documents are connected to national security materials, it is likely the US president would prevail before US federal courts in a legal claim related to the privileged nature of these documents. So let's look at that third issue. And remember, the third issue was whether the seizure of arms from several well-known United States companies by the US president is constitutional. And I want you to look at this issue very closely because it combines not only the application of rules derived from cases, but it also applies constitutional law provisions. And in many classes, you are going to be discussing not only rules derived from cases, but also constitutional law provisions. And this is okay to apply also in your exam. So in this particular case, we have whether the seizure of arms from several well-known United States companies by the US president is constitutional. And then basically the explanation is that the US Supreme Court in Youngstown v. Sawyer indicated that a seizure order adopted by a US president affecting United States companies must stem from the US Constitution or an act of Congress. This rule is applicable in cases where the justification advanced by the president is related to national security or war-related concerns. In the facts presented, there's no express constitutional language that authorizes the seizure of arms from US companies to deliver to other countries. It can be argued, like in Youngstown, that the seizure order in this case is not part of the president's military power as commander-in-chief of the armed forces under Article 2 of the US Constitution. There's also no specific act of Congress authorizing the seizure. Therefore, the seizure could be considered unconstitutional and could be challenged by the United States companies before US federal courts. And then we have an issue related to the 10-day detention of Laura by the FBI without a warrant and how it violates her and whether it violates her constitutional rights and in particular the due process clause of the 14th Amendment in the US Constitution. And basically, when you look at this specific description, I want you to look particularly about how not only it discusses the rules, but it applies them to the facts and how you can draw similarities and differences between the specific cases. And remember always that application to the facts. So in this particular case, basically the answer says the U.S. Supreme Court in Baker v. McClellan established that a detention and the manner in which it has been conducted can raise constitutional issues under the Due Process Clause of the 14th Amendment of the U.S. Constitution. Even though the court is very clear in indicating that the Constitution does not guarantee that only guilty persons will be arrested, there are due process requirements that must be followed to justify an arrest. The detention of Laura is different from the facts in Baker because it was done without the judicial issuance of a warrant. As Justice Stevens indicated in the dissenting opinion in Baker, in cases of pretrial detention, there's a heightened interest in the protection of the inmate, and these are connected to the U.S. Constitution. In addition, Laura's detention in this case has been for a longer period than in Baker. She has been detained for 10 days already without any sort of indication of any prompt response. And I always tell students, when you think of cases like Baker v. McClellan, it's good to think about alternative facts, when you're practicing. What would have happened if there would have been, a warrant, or if there's no warrant? It's good to think about different fact patterns and how they would apply to a specific situation. Okay. And then we have a last issue, can Laura present a habeas corpus claim at the state court level or submit a claim before U.S. federal courts under 42 U.S.C. 1983, challenging her 10-day detention? This gives you an example, especially this description, of how to use statutes, for example, and other sources of law that you may be or have discussed in your particular class, and how to connect them to your case analysis and specific exam answers. So for example, in this particular case, there are two federal statutes which provide potential remedies that Laura may wish to pursue to challenge her detention. Under 28 U.S.C. 2241, a person in prison may present a claim in state court challenging the legality of his or her imprisonment and present a request to appear before a judge. Under 42 U.S.C. 1983, a person can sue state officials for alleged violations of a person's rights under the U.S. Constitution and federal law. Both of these statutes are discussed in the U.S. Supreme Court case of Pricer v. Rodriguez, and in Pricer, the U.S. Supreme Court clarified that if a state prisoner is challenging his detention or its duration and the prisoner is seeking release, the sole remedy is a habeas corpus. In this particular case, remember that application to the facts, if Laura were to challenge the legality of her detention, since the detention occurred without a warrant and the prolonged length of the detention, she would have a strong case for a habeas corpus remedy in state courts. If she were to focus her claims instead on the conditions of her detention, since she's facing challenges having access to needed medicines, she may have a chance to prevail in federal courts by presenting a claim for civil rights violations under 42 U.S.C. 1983. So I wanted to share with you some final thoughts before we end this lecture. Remember to not leave exam studying until the last minute. This is very, very, very important. The reality is that this is a system or an educational system that really values having trained on that legal analysis, having absorbed those rules and that legal rationale from specific cases. Remember to rest, and remember your wellness, sleep and taking care of yourself. It's very, very important to succeed in our exams. And also, please remember to listen very carefully to any instructions your professors provide on your exams and ask questions before the exams. But remember, no contacting your professors during the exam period. And please feel free to reach out to me if you have any questions on this lecture. I copy my email, in this slide in particular. And lastly, I wanted to send you my best wishes, the best positive energy for your exams. Remember that you have worked very hard, and that will be reflected in your exams. I hope this lecture was useful to you, and I really thank you for your attention today. Thank you so much.